is from one of our email questions. It's from Cassie, but it has to do with all of these commercials that we hear. You know, when you think about the commercials and those long disclaimers at the end of every single one of them, does this actually clear the product from any lawsuits? That's what Cassie wants to know, and that's what all of us want to know.
Well, my short answer is no. I'll let BJ deal with that.
That's what I was going to give you. No, it doesn't, Sheila and Morgan. What they're doing is, you know, there's a number of ways to deal with putting a product out in the stream of commerce to make sure it's safe. One, and the basic one, is to design a safe product. The second way is, and the second thing is to make sure when you design the safe product that you manufacture it safely. You use good parts, you put everything together like you're supposed to, you have inspections so that it's properly manufactured. And then the third aspect is you need to properly warn users of any problems they might look for. So if there's a danger in that you can't design out, you can't manufacture it out, then you need to warn the people about it. And you need to be very specific about what those warnings are. And there's a whole field of expertise in litigation and in science called human factors. And that's basically goes into what warnings are and whether they're something that would convey the damage or the danger specifically to the user. And there's a whole bunch of litigation about that. But all these rapidly talked disclaimers in connection with drug ads is just that, so they can say later down the line that, well, we warned them, but that doesn't really do much.
Well,
doesn't do much good.
To put it all in perspective, Morgan, and we've talked about this on the medical malpractice. This is in terms of cost of prosecuting a product liability case, it's like medical malpractice cost on steroids. We, on one of the multi-piece rim cases, it's actually an RH5 degree multi-piece rim manufactured by a number of manufacturers, notably Firestone, but several different manufacturers manufactured it. And this is a base with a ring on it that has a 1/32 inch of design interference. And it would blow up with enough force to lift a passenger automobile 25 feet off the ground or catapult a bowling ball about a half a mile. And when they go off near somebody, they're either decapitated, they're truncated, they're maimed, or they're killed. And the last one we tried, it was a substantial verdict. It was a $19.1 million verdict. A young man had 1/4 of his head taken away, and he was rendered a triplegic. And there were numerous other cases exactly like this. But in all of the prior cases, they had been settled by the manufacturers, and with the settlement came what is known as a confidentiality agreement, which means that all of the material in the Firestone files that told of how much they knew about the danger of the product were sealed. So we decided we would go all the way through a trial with it. The point of the story is this: from start to finish, it took 7 years. The actual out-of-pocket expense in the case was over $500,000. And that does not count the time of all of the people in our firm and on the staff who went back and forth to Ohio to go through their files to make copies. You just, it's one of those cases where you just don't start it unless the potential damages are astronomical. And you don't get the potential for astronomical damages unless the injuries are truly catastrophic.